Welcome to the Secrets of Personal Injury Law with Colin Bober.
Hello and welcome to the Secrets of Personal Injury Law with Colin Bober. Colin is a personal injury attorney who has represented over 4,000 clients with a gross settlement recovery of over $50 million. I am your host, Kevin Rosenquist, and today's episode is The Price of Recovery, Calculating Future Medical Expenses in Injury Cases. Colin, good to see you again.
Happy to be back.
All right, so when it comes to medical expenses and personal injury claims, what types of short-term costs can typically be recovered, and how do attorneys work to make sure that all expenses are covered?
Well, there are short-term expenses or sometimes out-of-pocket expenses relating to, hey, you just got in an accident, I want to go to urgent care to get checked out, right? I mean, a lot of people don't have health insurance now, but they can go to an urgent care to at least make sure they're stable. There's nothing going on. They don't have to necessarily go to a full-on emergency room. It's just say, I want to go get checked out. And then, so you may have that out-of-pocket expense, and then you may need additional care after that, because usually between the 24, 72-hour mark, you start feeling really achy. And so you might start accruing some of those out-of-pocket expenses in the short term for therapy, whether physical or cognitive therapy, counseling, or anything like that. So you're going to have short-term expenses. But some attorneys can help you make a connection with a medical provider that'll see you and work with you throughout your case, so you don't have to absorb so much of that in your out-of-pocket expenses. And then sometimes, depending on how much insurance the client actually has, whether they want to get their car fixed through the at-fault insurance, which can take some time, or they want to go through their own insurance, depending on what covers they have, they may have some rental charges that they're like, hey, I got to go to work. I was just in a wreck yesterday, but my car's totaled. I need to go to work. So you may have those out-of-pocket expenses for rentals. So those little pieces can all be recovered.
So now let's move on to the long-term medical cost, the future medical costs for clients. Sometimes, obviously, people could require ongoing treatment, long-term care, possibly forever. You mentioned that in a previous episode, that this could be with them for the rest of their lives. How do you calculate the amount for that? I mean, I imagine there's not a formula, because every case is so different.
Yeah, I mean, well, the vast majority of clients, they'll go through a course of treatment, and at some point, all the doctors will say, we believe you've reached MMI, which is maximum medical improvement, meaning we've done all we can for you. We realize you're still in pain, but we've done all we can for you. And so then you start looking into pain management options, or maybe you're a surgical candidate and things like that. And so if you have to have, say you need a neck surgery, but they have to fuse several levels of your neck, that's going to change your life forever, right? And so there's a couple things you can do, one of which, depending on the extent of your injuries, you can do what's called a life care plan. And you can have experts look at all of your medical records and the recommendations, because a lot of those medical records will say, this client has reached MMI, and we believe over the next, year or two, that they're going to need 3 chiropractic visits a week for the next 2 months, 2 years, and we believe it's going to cost X thousand dollars. So each one of those documents will probably include some estimate of future care, that then you can take that information and provide it to experts who can develop a life care plan to establish the longevity of how much care this person is going to need in the long term, to help determine a value. Because when it gets into litigation, nobody can put a dollar figure on anything. It's all speculation. And the purpose is to come to an agreement between both parties. Because like you said, there is no fundamental number, right? And so your job is to present information that you can present to an adjuster or a jury to say, yep, that makes sense to me. We need to give this person this much money because of the damage model that they have for the future.
How important is the role of medical experts to determine the extent of future care needs?
Well, it's very important. I mean, what happens in litigation too is that the doctors who provide the care get deposed and countered in a trial, per se, to say, well, the plaintiff says that this treatment is necessary. Defense attorney is saying, no, it's not, right? So now you have competing experts based on their expertise to say, I don't think this treatment was necessary. And the other one says that they do. So you're getting in a fight. And so experts are very important, because then you also have to weigh the credibility of each expert. Well, if only one's been practicing for 2 years and one's been practicing for 30 years, I'm probably going to have more faith in the guy who's been doing it for 30 years.
Right.
It's all just a constant battle to determine what that true value will be based on the testimony that you get.
You do that during the negotiation process too, right? That's not just for a trial.
Well, the trial is when it comes out with the competition, competing interests. Because we've also had situations where we went to mediation. We have an expert on our side, they have an expert on their side. We're in two different rooms. We're not talking directly to each other because we're in mediation, but we're still throwing out competing positions. So that can happen at any time. A lot of times in the early phases, what they will do on the insurance side is say, we got all the medical records, we sent it up for peer review for between doctors and nurses and things like that. And they render the verdict as to what they believe is necessary. And so then that's how they place a value on it. So basically, all the way through the process, you're fighting about it in one level or another. Pre-suit, suit, mediation, you're always fighting about it. It's just who you're fighting with.
Do the complexity of injuries, such as surgeries, physical therapy, specialized care, how much does that play into it as far as or how much does that complicate how to come up with the right number?
It's only complicated because everybody's different, right?
Mm-hmm.
Not everybody receives the same type of care. Not everybody receives the same modalities. Not everybody has the same bill. Not everybody has the same diagnosis. So that's what you're trying to do, is get the doctor to tell you what the diagnosis is, how long it should last, what the severity of the damage is, and get them to render the verdict on what they think that means. My job as an attorney is not to make sure that the information is whatever it is. My job as an attorney is to take that information from a qualified professional and articulate to that to layman juries who've never been on a jury before and make that make sense. So I rely heavily, and every attorney should. If any attorney ever said, well, I don't agree with this report, this doesn't make sense to me, well, unless you have an MD next to your name, I don't care. I don't want to render a verdict on medical treatment. I want to defer that to a professional who knows what they're talking about. And so that's the only complexity, is that everybody's different.
You mentioned, I'm sorry, I think it was MMI before?
Yes, maximum medical improvement.
Maximum medical improvement. So before you can get the lifetime care or the long-term care kind of conversation started, does that burden have to be met, the MMI?
It's not, I wouldn't call it a burden in terms of like a legal standpoint. It's just the point where the doctor says, we've done all we can. If we do any more, you're just at a plateau.
Okay.
Right.
Okay.
So, and a lot of times it comes in if you're going to physical therapy, or if chiropractic is your choice, if that's what you're doing, they say, yeah, you've had, 3 to 4 months of chiropractic care. You're not going to get any better if you haven't already. Therefore, we need to move you to the next phase. Maybe we need to start talking about some kind of pain management, or maybe we need to start looking into some surgical intervention. Those benchmarks should be met as good practice, because it's not reasonable to go go in an accident and go straight to surgery, unless you had something traumatic, obviously. I mean, that's a necessity. But if it's just some kind of soft tissue injury that doesn't require any stabilization or anything, you have a duty to mitigate your damages and start conservative and ramp up based on medical necessity, than to go from 0 to 60 in 3.5, right? And so that should be done as good practice, because no jury would reasonably go, well, you only went to the hospital, you went to physical therapy twice, and now you're a surgical candidate all of a sudden? That doesn't make sense. And that's the information that you have to present in a way based on the damage model to a jury, so they know, okay, well, they tried to be conservative. They went through steps. It didn't work. That's why we're here. That's why the dollar figure is what it is. That makes sense to me. I would do the same thing. Let's give them the money.
And what all, as far as future medical expenses, I mean, obviously future surgeries and things like that, large things that goes without saying, but are there other aspects that you can look for, whether it's, like you said, like if you never really had to go to a chiropractor before, but now you find yourself having to go once a month just to maintain, does something like that fall into that long-term care medical expense kind of situation?
Yes, it does. But again, it's a conversation from the insurance company on both sides, from the plaintiff and defendant side, to come to an agreement on a lump sum payment.
Okay.
Because they're not going to leave it open-ended for a number of years. They want to narrow down the expense. They want to lock it down and be done with it. So that's why when it comes to the future care and you do the damage model with the future care plan, you can at least put a number on it so you know what you're accepting and releasing on the insurance side. Mm-hmm. So yes, you can absolutely include that. But the point is, that's why we tell our clients, you need to make sure you're comfortable with how you feel before you move on to settlement, because once you sign on the dotted line, there is no going back, right? And so we want to make sure we get all the testimony and all the medical documentation to ensure that that number, when you sign, you're good with it, because that's the end.
When you're seeking compensation for future medical expenses for a client, does the legal process differ as opposed to immediate or past medical costs? Are there extra challenges that you face in these cases?
Well, the only challenge you run into with future damage models like that is, insurance, we don't think it was that severe, so we don't think that that's reasonable, right? So you have an MD saying the client needs a cervical fusion as a 31-year-old, which is pretty intense.
Yeah.
And then you have insurance adjuster saying, we don't think so. Well, that's when you're really fighting about it. And that's when, like you said, you have to bring in those experts and say, this client is a 31-year-old, should not be in this position. On the mechanism of this accident, with them getting rear-ended, T-boned, whatever it was, he needs it because of a direct connection between the accident and the injury, which goes back to your negligence question. If you can establish the causal link between the accident and the injury, you're good. And if you can, then they should be obligated to pay it. But you have to be able to establish that, and sometimes that requires an expert.
Does it extend out the trial or the case more when you have to try to fight over future medical costs?
Usually the case is going to drag out for as long as the deadline's required to be. In terms of when you file, you'll get a scheduling order, and the judge will tell you, all right, on this date, you guys better be ready to go to trial. So whatever we work out in the interim, that we could potentially resolve it before the trial, which could be a lot sooner. Or we could have to wait till the trial date, which may not be 2 years from the date we filed. So I wouldn't say that it drags anything on once we're in litigation, because we have a set date that we have to prove this thing in front of a jury. But yes, it will increase the longevity depending on how many people that we have to bring in to prove whoever wrong.
Yeah. How long does it usually take between offers? Like if an insurance company makes an offer and you're like, nope, that ain't going to do it, go back to the drawing board. What do they have? I'm imagining there's a certain time they have to come back with another offer, right?
In pre-suit, before we file a lawsuit, we'll give them a deadline. And if they don't meet the deadline, then we obviously file suit. In litigation, there is no other recourse because you've already filed suit. Right. So either they're going to make you a new offer, or they're just going to go on to the next phase. They'll say, nope, we're not going to make an offer until after the depositions. Or nope, we're not going to make any offers until we get to mediation. Like, you've already escalated it to a point where you've used all the leverage you have, so that now the only way to push the envelope is to get it in front of a jury, unless you come to an agreement sooner.
Do you have any cases that you'd like to bring up as far as, how the future medical care might have been like a key element to the case?
Yeah, we had one where a client was rear-ended by a company vehicle. If I remember right, he hit his head on the window.
The side window?
Yeah. And he was diagnosed with a traumatic brain injury. And we went to mediation. And like I said, we had our expert on our side. They had theirs. Their expert said that there was no way that he could have gotten it, a TBI. And we said, we don't agree with that. And so with the help of the mediator, we came to an agreement, going back and forth with all the details, because the traumatic brain injury is not something that resolves within a short period of time, and then it has a bunch of external factors that goes with it. If I have a traumatic brain injury, I'm going to have lost wages. I'm going to have the loss of function. I'm going to have the inability to sleep. I get irritable with my spouse. Those things are aspects that come out of it, even if it's just a TBI on paper. There's so much more to it, and those are the details that we fight about. Even if you don't agree with me about the TBI, you still have to address these external issues.
Yeah, that's one thing about traumatic brain injuries. Yeah, you're right. There's so much more to it than just the initial injury or the headaches or whatever. There's so many nuances when it comes to that, which obviously we've learned so much more about. And you and I are big football fans, and
yes,
we've certainly learned a lot more about traumatic brain injuries, even in sports and in situations like that. So it makes sense that you've got to really look at every angle of a TBI.
Right, and that's kind of the how the fight always goes on. Cases drag on because we're arguing one side, the other side is arguing the other side, and the only person who can break the tie, unless we get an agreement, is a jury as to who's more believable than the other.
Yeah, what a tough spot to be in too.
I enjoy it. I enjoy it because I always think I'm right.
Well, I'm glad you enjoy it because someone's got to. If we're all gonna get represented, all of us people.
Yes. Well, I mean, that's why we always want to take care of the people who are genuinely injured and need the care and attention. And, and like I said in a previous episode, if you're not one of those people, it's something you can easily handle on your own, and you should.
Absolutely. Well, thank you for tuning in to the Secrets of Personal Injury Law with Colin Bober. To connect with Colin and his team, visit boberlawfirm.com, and please like and subscribe to our channel and leave us a review. Colin, great seeing you again. Thanks for all the insights.
Yes, sir.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.